Welcome everyone to Tuesday Afternoon Networking. We're now live on Zoom, Facebook, YouTube, and 一直播. I'm your host, Coco T.A.N. I'm a realtor with Keller Realty in the San Francisco Bay Area. If you have been attending those seminars regularly, you may have noticed that we have switched to a tri-weekly schedule now instead of bi-weekly. That is because I have been really busy with helping buyers and sellers. Everyone knows this is a hot market right now for real estate. My new listings usually stay on the market for less than 1 week. The only way to stay up to date on all of them is connect with me on WeChat and subscribe to my YouTube channel. This is my QR code for WeChat, and this is the one for YouTube channel. My WhatsApp app is also down here. I appreciate all of you that have already connected and subscribed. Let's get right into it. Today we have real estate attorney David Bonaccorsi with us. He's a partner with the law firm of Bernard, Bagley, and Bonaccorsi LLP, and has been practiced law in Fremont and Newark since 1987. In addition to representing commercial and residential landlords in private practice, Mr. Bonaccorsi is the legal advisor for the Chinese American Real Estate Association. You may remember him from his previous seminars about dispute resolution and about evictions during COVID-19. Today, he will be talking about our state's renter protection laws again, but not about COVID-19, because the pandemic will not last forever. To be optimistic, I might even say we are close to the end of it. For realtors like me, that means open houses again. For tenants and landlords, it means the expiration of the SB 91 and the lifting of the eviction moratorium. What will happen then? Well, it will revert to the law that existed before, which was called AB 1482, also known as the California Tenant Protection Act of 2019. Starting January 2020, landlords must have just cause to evict a tenant, and there is a cap on the amount rent can be increased every year. That is our focus today, and who better to discuss real estate law than a real estate attorney? That's what Mr. Bonaccorsi is here for. Hello, Mr. Bonaccorsi, how are you?
Good evening. I have to unmute myself first. Thank you, Coco. Wonderful.
Thank you for joining us today.
Absolutely.
So what would you like to share with our audience today?
Well, hopefully I'd like to share my PowerPoint as well as my own comments. So if we could load up the PowerPoint, I'd love to see it and we can go from there.
Great. Are you sharing your screen or do you want one of us share with it for you?
I can't multitask very well. So if you could do it for me, then I can focus on what I'm saying rather than worrying about share screen.
Okay, maybe I have Anna take over. Share the screen of the PowerPoint slides.
And while we're looking for the slides, I'll just do a general introduction. What I'm going to be speaking about this evening is really for informational purposes. It's not meant to be construed as legal advice. If you want to follow up with me or with any other attorney on the matter, please contact the attorney of your choice. But thank you, Anna, for loading this up. And I'm going to ask you to change the first page. Would be great if we could see the entire page. I have a black box in front of it. So if you can go back one, and that's my, nope, you're going forward. If you could go back two now.
Trying to get rid of the black box.
There we go. One more, we can go back. There we go. Let's go to the first page after this one. Thank you. And I will provide the PowerPoint as a courtesy to anybody that attended, and you can use it as a resource. Could you go back, Anna, before we go forward? You're going ahead of me a little bit. Let's go back to the first page after the title. And if you go to the next page, that'd be great. Page 2. Okay. There we go. And we'll hold off for now until I tell you to go to the next page. But before I get into this, I thought Coco's introduction was absolutely perfect because I've been practicing law since the 80s, and most of the law had been at the state level. And aside from communities like Berkeley or Malibu or Oakland or San Jose, there had not been much attempt to have rent caps or rent control. And certainly there was no statewide law that did this. So we thought the huge development in 2020 was going to be AB 1482. And so I gave a webinar at Metro Crossing, which is the new Toll Brothers development, right across from Warm Springs BART station on February 20th, 2020, and thought, okay, I'm going to be giving a lot of webinars on AB 1482. And then less than a month later, the pandemic hit, and we have been dealing with moratoriums and local eviction moratoriums and statewide eviction moratoriums that have been at play since March of 2020. I will, when we get to slides 8 and 9, talk about how AB 1482 has been applied to the legislation that our state legislature has enacted to provide additional renter protections during COVID. But to understand AB 1482, you need to understand something called Costa-Hawkins, which was a state law that passed in the 1990s, mid-1990s. And it was an attempt, a kind of feeble attempt or a feeble compromise between landlords and other interest groups to stop cities from enacting rent control. So what it did was it preserved rent control ordinances in places like Berkeley and did allow cities, if they wanted to enact rent control going forward, but it really had to apply to older construction that was before February of 1995. So the further away that we've gotten from 1995, the less impact rent control at the city level has had, because there's been apartments and other units that have been built since then. So any attempt at the local level was going to not help all of the tenants within the community. But one of the important features that Costa-Hawkins preserved for landlords was something called vacancy decontrol. And that's preserved with AB 1482, which is once a tenant leaves, you may have certain rent caps in place that would create a rental situation where the rent is below market rate. But once that unit is unoccupied, you're able to lease to the next tenant at current market rate, whatever the market will bear. One of the things that I want to talk about, because AB 1482 is all about disclosure, but a general rule, and I know many of you may speak Mandarin. If you're realtors, you may, or owners, you may negotiate in Mandarin, and we may have other languages here spoken primarily with people, negotiating with people in their own language. There is something that's important called Civil Code 1632, that if you negotiate a lease primarily in Mandarin Chinese, you need to provide a Mandarin lease written in Chinese. And that also will hold true for the forms that I'm going to show you today regarding AB 1482. If you don't, the tenant may be able to do what's called rescind the contract and make it unenforceable. So it's very important that if you have a realtor that you get the forms in Chinese, if you're doing that in Chinese. We'll be talking about the effect of AB 1482 on what was historically 30 to 60 days notice to terminate. In the olden days, if you wanted to tenant out, you could just give a 30-day notice and say bye. Then the legislature said, well, if they've been there more than 12 months, you got to give them at least 60 days. AB 1482 has a significant impact on the renter that's been there for at least 12 months. Next slide, please. AB 1482 is about exemptions. We're going to talk about the fact that there are certain types of owners that if they lease property do not have to apply AB 1482 rent caps or just cause eviction standards. But I call them the snooze and lose provisions, because the legislature plays gotcha. If you don't do the right disclosure, if you don't disclose to the tenant that you're exempt, then you're not exempt. So what AB 1482 in the broadest possible terms addresses are rent caps and limitations on how much rent you can increase in any year, and just cause eviction. Again, the 60-day notice in the olden days, or if you're an exempt property, you don't have to give a reason. But now, in order to have a valid notice of termination, not only do you have to give the proper amount of time in the notice, but you have to state a specific reason that is authorized under the law. And if you don't state the specific reason with the proper wording and or proper disclosure, you may not be able to evict on that basis if you go to court. Again, there are going to be required disclosures that you have to comply in the language you're negotiating. So again, if you speak both Mandarin and English, and you're speaking with a Mandarin speaker, the best thing to do is to negotiate primarily in English if you can, with the tenant if you can, so you avoid having to do the translated documents. 60-day lease termination, that again applies to 12 months or more. And as I said, now there's got to be a reason to terminate. Do local rent control just cause eviction ordinances still apply? Yes, they do, and they may. And I'll tell you the test for determining whether they do. So when I talk about AB 1482, if I get questions from people that live in Oakland or have rental property in Oakland or San Francisco or Berkeley, I'm not going to answer them, or San Jose specifically, to those areas, because that's not what AB 1482 is intended to cover. It's intended to cover places like Fremont that I know a lot about, which does not have any rent control. There was an attempt a couple of years ago to do so, but the council has repeatedly pushed back efforts to have rent control in Fremont. So in the absence of any rent control at the local level, AB 1482 is the law that's going to regulate non-exempt properties. Next slide, please. Here are the exemptions. We're going to get to a form that's going to repeat them for you. There's a rolling 15-year certificate of occupancy requirement. So if you happen to own property that would otherwise be subject to 1482, but it was built and what's called the certificate of occupancy was issued less than 15 years ago, AB 1482 doesn't apply. Well, the law was enacted effective January 1st, 2020, as Coco had mentioned. So that meant that any property January 1st, 2020 or later was not subject to AB 1482, but it's a rolling exemption. So you have to measure back in time from today. So now property in January 1st, 2005 is subject to it, but now it's 15 years, which would be basically from May 11th, 2006 up to the present. So it's a 15-year rolling exemption. So if you've got newer property, it will be phased out and will be subject potentially AB 1482, the older the property becomes. Single family residential rentals are exempt, okay? That everybody says, well, I don't have to worry about AB 1482. I got a single family, I'm renting it out. And so I'm gonna clock out. I'm not gonna listen to you, Bonaccorsi. I'm done. We don't need to worry about AB 1482. I'll move on and do, pretend like none of this applies to me. Well, there's what I call a snooze or lose or snooze and lose provision, which means that unless you have the just cause addendum that I'm going to show you attached or in the same similar form attached to your lease at this point in time, you lose. You have to both have exempt property and disclose it to the tenant as part of an addendum to the agreement. If it's not there, and you go in and set out a 60-day notice for your tenant that's been there for 3 years or more in your single family residence, they can say, well, where's my just cause? You didn't give me a reason why you're kicking me out. You say, well, I'm exempt. And they're going to say, well, I don't have an addendum. So you're going to go in front of the judge and likely have to start the process all over again. So single family is exempt, but within that only applies if you're like a mom and pop owner. So no real estate investment trusts can be the owners. They're subject to 1482. Corporate owners of single family units are subject to 1482. LLCs are not if they have no corporate members. So if you want to form a husband and wife, or 3 or more of you form a partnership, you're all individuals as members of the LLC, that LLC can be exempt from 1482 if all of the members are not corporate entities. But again, if you are an LLC, you still have to do this disclosure, or else you have a gotcha and you're going to be subject as the owner to AB 1482. Other exemptions, you can rent out your own property up to 2 bedrooms, but bedrooms 3 and 4 become subject to AB 1482. If you're in a duplex, you live in one and the other you rent out, that's exempt again. If you have a shared bathroom and kitchen in a shared living arrangement, regardless of the number of people that live in your house, if it truly is shared and there's no separate kitchen or bathroom area for your tenants in your own home, then you're exempt from AB 1482. There's a number of other ones, affordable housing. Nobody here is in that area. But if you have a deed restricted property that is for qualifying residents, they have their own rules. And again, local ordinances may exempt the owners from AB 1482 because they're under tougher restrictions as a landlord. Next slide, please. Rent caps. The other feature of AB 1482 is, or a major feature is rent caps. The rent increases are capped at the lower of 10% or 5% plus regional CPI inflation. And Coco just invited the audience to email her if they want a copy of this, because I provide you the hyperlink to find out what the price index is, and you can determine in your area what that will be. So in Alameda County last year when I did it, I haven't checked it because it hasn't been my focus for the last year and a half, but last year the CPI was 4.1%. So that meant that the annual rent increase could be no more than 9.1% because it was less than 10%. 5% plus the regional CPI inflation for Alameda County, which was then 4.1%. If there's no regional CPI, then you go to the California CPI, but we do have one in Santa Clara County and one for Alameda County. There was a clawback provision that increasingly becomes irrelevant the further that we get away, but if you look back to March 15th and you had increased more than that 9.1%, then the excess rent either could be reimbursed or credited to future rent. You can't do a sublease. You can't kind of conspire with your tenant to say, hey, look, I'll allow you to sublease, but you have to add a couple $100 to my rent payment for the privilege of subleasing it, whatever you sublease it to. It has to, the total amount of rent from a property cannot exceed as between the tenant and the landlord. The landlord cannot receive more than the caps if the rent caps apply. Next slide. There we go. Just cause eviction. This is the other leg of the two-legged stool that we have on AB 1482, rent caps and just cause eviction. And you'll see me refer to it as JCE as a shorthand. There are now specific defaults in rent. There's a default in rent or default. Rent is a default. But again, until the COVID-19 is lifted, we need to look at the either statewide limits or for an Alameda County local limits on evicting somebody for rent. And if you've been to my seminar in Citra and SB 91, you know all about the limitations on collecting no more than 25% of the rent for a tenant that's declared hardship. I'm happy, this is almost like the second semester of a college course. Your required instruction was my seminar in Citra and SB 91, but I can happily answer those questions in the Q&A period to get us up to speed. Suffice it to say is when COVID-19 is lifted, it'll go back to whatever the rent was, and you'll have to utilize the AB 1482 requirements. It used to be you could give a 3-day notice to pay rent or quit for a default of rent or any other kind of default. It's not only 3-day notice, it's a 3-day notice to cure if curable. And then if they don't cure it, then a 3-day notice to quit. So it extends the period of time before you can hold a tenant in default before you can go in court. Other defaults that exist under AB 1482, if they're engaged in criminal activity, if they improperly assign or sublease without your prior written consent, if there's a non-renewal of a fixed lease by the tenant, that's a basis. Let me footnote that. For the landlord, under AB 1482, one of the headlines you may read, which is true, is there's no such thing as a fixed term lease anymore at the option of the landlord. It could be fixed term only at the option of the tenant. What do I mean by that? So you've got a 2-year lease that expires. In the old days, before AB 1482, you simply give out a 60-day notice in advance of the expiration of the lease. You go into court and say the lease is expired. That's all that exists. Now, if you're the landlord, you have to offer you the same lease terms to the tenant under substantially similar terms that you previously had under the 2-year lease. And if the tenant, only if the tenant refuses to renew under those terms, can you then, and the tenant doesn't vacate after the expiration of the lease, can you go in as just cause basis? But the landlord can't not simply say, well, my 2-year lease is over. It says 2 years on the contract. That's it. AB 1482 rewrites that and allows tenants effectively, if they never commit a violation of the lease, if they are always on time for their rent payments, with limited exceptions, if you sell the property, obviously, and remove it from the rental market, we'll get into no fault. But for just cause purposes, the tenant could be there forever under AB 1482. Next slide, please. Here's the no fault just cause. There's a family move-in. If you want to have your family move in, and families can be grandparents and includes you yourself or your wife. You know, if you're Bill Gates and Melinda Gates now wants to move into your property, if you had a family move-in provision, Melinda could kick you out. Okay, but Melinda bought a multi-million-dollar cottage, so she's not going to be subject to AB 1482 in the state of Washington. But that's the idea, that you have your kids or your separated spouse can move in. But again, it's a snooze and lose provision. There's a form that you have to check in that you want to exercise that right to move in. If you don't check that box, then that cannot be a basis for kicking out the tenant, for removing the tenant from the property. You want to remove the property from the rental market. That's becoming increasingly a favorite of landlords because they never got into business having to hire an attorney and an accountant and everything else to be able to stay up with all the regulations at the state and local level. Has become very complicated. And given the hot market that keeps Coco T.A.N from having biweekly seminars, part of that reason is that people are giving up as owners. And so one of the, again, this, I'm going to wear my public policy hat. We don't have enough rental housing. We don't have enough affordable housing in the state. So AB 1482, like a lot of rent control legislation, has winners and losers. If you're in a rental unit, you're a winner, but there are provisions that really make it difficult for the rental community as a whole, because the incentives structure right now under AB 1482 may unfortunately remove rental property that was previously there, and therefore has the effect of putting upward pressure on the remaining rental property because there's fewer units in inventory that are available for rent for people that cannot afford housing, and that's most of us. But removing property from the rental market is a just cause basis, a no fault basis that you can utilize in your 60-day notice to terminate a lease if they've been there for more than 12 months. And in Fremont, that's all you need. But if you're in a place like Berkeley or Los Angeles or San Francisco, there's something called the Ellis Act, and that's far beyond the scope of my discussion. That's a whole nother area where cities are authorized to set up very specific rules and timelines to provide relocation assistance to tenants over a period of time before you can remove the property from the rental market. But most jurisdictions do not have local Ellis Act legislation, and there's some efforts now by the legislature to remove the Ellis Act as a protection for so we'll see how that plays out. Demolish or substantially remodel. If you need to go in, and painting doesn't count, but if you need to upgrade your property, you can utilize that for removing the tenant and then bringing a new tenant in with the upgraded property. However, we're going to get into it on pages 8 and 9 in the next couple of pages, or 9 and 10. That's been limited under COVID legislation, and I'll talk about that in a minute. But basically, you have to, when AB 1482 is the law again, post-COVID, post-eviction moratoriums, you have to basically show that you're pulling a permit and doing substantial remodeling, and you really need to be doing it. I had one real estate agent say, well, my tenant really doesn't like the low rents. She'll just say that she's doing a substantial remodel, and who's going to check? And we'll just get out of jail free and get the tenants out, and that's our just cause. Tenants were paying the wonderfully below market rate rent on time because it was below market rate rent. It was very affordable. But the problem you run into is if you fraudulently claim that, if I were an attorney representing a tenant, and tenant advocates are going to be really sharp on this, they would check the city that you're in and see if any permits have been pulled, any applications filed, and raise a question whether this was a legitimate claim. Or worse yet, if they stumbled through that, or the tenant stumbled through it and wasn't adequately represented, finds out that some other tenants moved in 6 weeks after they vacated at higher rents, they can go in and sue the landlord for a tort for wrongful eviction, which could subject the landlord to far more than the difference in rent that they thought they could get in the short term. So don't play around with that excuse. And right now during COVID, it really is off the table, as I'll explain. If it's for no fault, again, if this is non-exempt property, if you haven't exempted it as a single family house, if you're subject to AB 1482, you have to give a relocation benefit within 15 days of the notice. You either have to tell the tenant you're going to waive their last month's rent, or basically pay them the equivalent of 1 month's rent as their relocation benefit to assist them in moving forward to the next unit. If you don't pay that relocation benefit, even if everything else was perfectly justifiable for the no fault basis, that's a basis for the court to deny your unlawful detainer eviction and enter judgment at great expense to the landlord. Next slide, please.
AB 14 ఏదో చెప్పాడు 1940 ఏదో
I hear somebody talking in the background, Coco. So but
yeah, so maybe everybody please mute yourself for now.
Okay.
And we will open up for questions and answers in a little bit.
There is a car form. Again, if you have a realtor or you are a realtor, become very familiar with these car forms. They take these complicated statutes and put the forms together that have all the right languages. And I realized after I gave the slide to Coco that this is 2 out of 3 of the pages. There is a third page, but what it does is it really is a shorthand summary of everything I've just talked about, of the rent cap requirements, the just cause requirements. And then most of you are going to be interested in the specific exemptions to both rent cap and just cause eviction. So if you look at the lower right-hand side, and I don't know if you can zoom it, but there's a little box there. This exemption only applies if the notice below is checked and delivered to the tenant. That's the box I told you about, the snooze and you lose provision, that if you don't check that box, even if you're single family or if you're got a condo and you're, mom and pop owner, if you don't check that box and give notice to them, to your tenants, the tenants are going to say they have all the rights, so they are entitled to all the rights under AB 1482 as non-exempt property. So this is the form you want to make sure you have if you're leasing out property. If you're a tenant, you want to make sure that the landlord is giving you this. And if they haven't, you have greater rights, whether or not the landlord may be exempt or not, than other tenants that properly should have been given this notice. Next slide, please. This is the headlines today. And I know Coco is focused. I'm optimistic too. I'm thinking, my thought is this. Back in September, SB 90 CITRA was passed. The expiration for the rent caps during an eviction moratorium statewide was the end of February. I knew that wasn't going to be the only period of time, but they needed to get something passed. It was the end of the legislative session in 2020. They needed to get something passed, so they compromised and got enough votes. 2/3, you need 2/3 of the vote of the legislature to have the law go into immediate effect as opposed to the January of the next year. So this was the balance that it expired on February 28th of 2021. Well, at the very end of February, they enacted, the state legislature enacted, governor signed into law, SB 91, which has the state eviction moratoriums apply all the way to June 30th, okay? Again, these are, if you saw my other seminar, we went into great detail. This is the statewide eviction moratorium laws that apply unless there was a moratorium enacted before 8/19/2020 locally. And for those of us that's more tenant friendly. For those of us that live or have property in Alameda County that's being leased to tenants, Alameda County is the rule here, where I'm speaking from in Newark this evening, but in Santa Clara County, SB 91 is the rule. But this is what happened that affects AB 1482 until these moratoriums are lifted. My prediction is there's probably going to be one more extension, and for good measure, they'll probably kick it out to the end of the year. So when we get into May or June, look for the legislature hurriedly to pass one more extension. You know, we're now having the emergency use authorization for vaccines for 12 to 15-year-olds. And I just saw today that they're not going, they may have vaccines for children by the first quarter of 2022. I do think we're going to get to normal by the end of the year, certainly by September for schools. But I do think that because the interests are aligned in such a way as to protect tenants, secondarily, and this is secondarily, although there are certainly tenant advocates that are have strong influence in the legislature, the primary goal of all these moratoriums is to reduce mass displacement of tenants. And the longer we've gone, the more horror stories there are out there, I'm sure, of tenants that have been paying very little rent or barely enough rent under these moratoriums to stay in their place. And once you lift the moratoriums and the suspension of full rent is lifted, there's going to be a lot of evictions that are going to happen, and people are going to be kicked out. It's going to be a real chaotic situation for many, many months. Legislature, I think, is going to probably kick the ball down the field a little bit, and I would anticipate again in June seeing these moratoriums stay in place, even if we return to quote unquote normal before then, probably until December. So you need to know about these effects of AB 1482 during the pandemic. Before July 1st, 2021, and again, if SB 91 is extended, as it did with Citra, they're going to extend this as well. SB 91 expands no fault and at fault just cause eviction to unlawful detainer actions. So if you're a single family home, have a single family home, your mom and pop, you just gave that little check mark to the tenants, you did all the right things, you have the just cause addendum, and you say, hey, I'm exempt from AB 1482. No, you're not. No, you're not. Just as long as SB 91 is in effect through July 1st, and if extended, likely it will be extended as well. So now you're going to have to go through the just cause eviction on defining not, if they're engaged in criminal activity or if there's a nuisance, all of the things that were for cause, or you have to show that, you're removing the rental property from the market, from the rental property market. The rent, however, as a default is going to be governed by SB 91, and you have the declaration of hardship and collecting no more than 25% of the rent. So that's going to be skewed. It's not basic rent. It's going to be governed by SB 91. So again, if you have a property that's less than 15 years old and says, hey, look, I'm not covered by AB 1482. Yes, you are, until July 1st, 2021. And it was a section of SB 91 that's a lot of information in a couple of paragraphs there. Next slide, please. This is one I was referring to, it foreshadowed earlier, the substantial remodel, no fault exception to just cause eviction. Basically, the only time a substantial remodel just cause eviction will be authorized or justified is if you have a public agency saying you need to remodel because there's a health or safety hazard. So unless you have a slip of paper from a building inspector, if your house has been red tagged, only those situations through the pandemic, through SB 91 and beyond if they extend it, will that be a basis under that prong of what's considered just cause to be able to remove a tenant? And there is one benefit for landlords that are otherwise exempt. If you're that single family homeowner that has the just cause addendum and you have the check mark, you don't have to give a relocation benefit to your tenant if you have a no fault basis. Only those that are subject to AB 1482 are required to do so. So that's the one compromise where the legislature said, okay, if you're otherwise exempt, we're putting all these additional burdens on owners and landlords, but we're not going to put the additional burden upon you of having to pay a relocation benefit. Next slide, please. This is a very interesting situation. You can engage in the sale of property only if you're an exempt owner to a buyer who's exempt. If you have a tenant occupied property, what does that mean? You have a seller who is not a corporation of a single family home, for example, or a REIT or an LLC with only individual members. You can sell, but you cannot sell to a speculator or an investor who's going to flip it. You have to sell to a buyer. And it has to be on the market. I'm going to show you a form that the realtors out there need to know about, because you could run into a situation where you have an owner occupied, a tenant occupied property. You need to disclose that if you're the seller. But if you're the buyer, you're going to have to be really concerned that the buyer may not be eligible to remove the tenant as long as SB 91 is in effect as a basis, unless he goes through the process correctly. And if you're exempt, then you can do it. And again, as I mentioned, relocation tenant benefit is only for non-exempt owner landlords. If you're exempt otherwise on AB 1482, you don't have to give the relocation benefit. And this is complicated, but I'll read it. Unless non-exempt owner required to offer relocations, no COVID-19 rental debt for UD under section 117.9.05 for no fault or at fault just cause eviction. So you're a non-exempt, which means you're subject to AB 1482. Remember, you're only required to offer relocation benefits for a no fault relocation. Let's say you're at fault, the tenant's at fault. Let's say the tenant is assigned or subleased his property without permission. You can go in for a just cause at fault eviction, but let's say the tenant is also behind on rent. You can't use the landlord tenant. You can't use the unlawful tenant procedure to collect on any of the rent that's been deferred under SB 91. So again, for those of you that saw my seminar or have the PowerPoint, go back to it and refresh your recollection. If a tenant is declared hardship, they are entitled to pay no more than 25% of the rent that's due over the period of time until SB 91 ends. So that 75% of the rent is COVID rental debt. Well, you can't go in and sue for that rental debt through this process if you're doing a just cause eviction for at fault, which means to me that you could get maybe you could have to defer anything above the 25% that they're paying to small claims court down the line and recover possession only in this process. And remember, COVID rental debt relief is going to be through small claims beginning on August 1st. And for those that are eligible as tenants that subject to hardship because of COVID-19 and they haven't paid rent and they don't get caught up, that's where the landlord has to go to try to collect that unpaid rent. So it's a very complicated provision. I don't want to spend too much more time on it. Even in answering questions, it's very hypothetical. I really would hope that you would ask for an attorney to advise you if that's this unique situation you're in, but it shows you how difficult that section 18 of SB 91 is, that has a lot packed in trying to balance between keeping tenants in place and AB 1482 with a limited expansion during COVID. Next slide, please. Do local rent control just cause eviction ordinances still matter? The answer to that question is yes, depending, okay? And let's go to the next slide to know whether your local rent control still exists after AB 1482. AB 1482 does not apply under one of two circumstances. If the local just cause eviction was enacted before September 1st, 2019, or enacted and amended after September 1st, 2019, if more restrictive. So if the city gets involved in enacting just cause eviction, they're going to have to come up with more tenant-friendly reasons that are higher standards than AB 1482 in order for the local ordinance to apply. Again, this is really theoretical at this point, but something to watch for after the COVID is over. Right now, local cities, counties, and state has been involved in triaging the pandemic, and so haven't been focused on trying to create just cause eviction statutes, because the eviction moratoriums prohibiting or banning or really strongly limiting access to the courts to evict anybody have been more than enough to dampen any efforts by landlords to evict tenants. Once the COVID-19 is lifted, there may be some more efforts by some local cities to get involved in trying to provide greater protection to their residents if they don't have a just cause eviction statute or ordinance in place already. AB 1482 rent caps do not apply if local ordinances have more restrictive rent control than AB 1482. Again, Berkeley is an example where the rent caps or rent control is much more restrictive on tenants there than the 5% plus the CPI, or up to 10%, whichever is lower. So you're going to have, it's like three-dimensional chess with Costa-Hawkins and multi-tiered rent regulations. Prior to February 1st, 1995, you're not going to have any cities get into the business of rent control for units that were built after 1995. And even after AB 1482, you may start seeing some jurisdictions that still attempt to legislate just cause eviction standards or rent caps that may be tougher than AB 1482. But basically, simplistically, again, you got to go to an attorney to find out where your property is, which law applies. But simplistically, if you had a local ordinance in effect before 2020, likely the local ordinance applies both for rent caps and just cause eviction. If you didn't, likely AB 1482 applies. Next slide, please. What is the realtor's role in representing a buyer or seller in a sale of residential property where an existing tenant occupies the property? Well, I got into this a little bit. Let's go to the form, the next page. Your realtor should be familiar with this form. Next page, please. This is a notice of termination of tenancy prior to June 30th, 2021. Actually, it's a typo. It really should be prior to July 1st, 2021, because on June 30th, this would still apply. This is the CAR form that every realtor should become familiar with, which is, I guess, the CAR form NTT-Citra revised February of 21, if you've seen the parentheses on the heading. And this goes through the properties that are covered by Citra, and then if it is, what you need to do in order to be able to evict a tenant. And I had a situation where a buyer came to me and says, well, I have a tenant still in my house. And it turned out that it was an off-market sale between brother and sister. Well, it doesn't qualify. You have to have something where there's a market listing with an escrow. You have to have it done within a certain period in order to qualify, in order to give it, whether it's 60-day notice or a 30-day notice, depending upon the circumstances. So if you're a realtor representing a buyer or seller, if you're in that situation, you're going to find out, what applicable exception applies, if any, to the seller to be able to remove the tenant, and has the seller done whatever the seller needs to do in order to begin the termination process, so that you can try to build escrow around a contingency or of removal. But again, if you're in Alameda County, you can go in for an eviction based on removing the property from the rental market, but it just takes a long time to get into court. So if the tenant does not leave, you can be looking at a lot of extensions of escrow or escrow cancellations until as long as SB 91 and Citra apply to the property and the sale. So there are many questions there, but all I'm trying to do within the confines of this presentation is raise the issue that if you see that a tenant is occupying the property, it should be listed on the MLS if you're a realtor, and it should be on the car residential form. There's a box which makes it a seller contingency. And I had another situation recently, and I don't know if I discussed this at the last seminar, but there was a situation where the seller had a tenant occupying the property, and the seller was trying to, and he was not represented by a realtor, beautiful home out in San Ramon, multi-million-dollar home, was trying to save a few pennies on the commission, which I thought was a disservice to my buyer who became my client. Basically, it was trying to shift the obligation to the buyer and say, well, you gave me a no contingency offer. Your lender has approved the loan, but whether they approved the loan or not, you're in to finance the purchase of this home. It's not my problem. Well, no, under that CAR form, it is a seller contingency independent of the no contingencies of the buyer. And if you're representing a buyer, you never want to waive that or shift it or say, hey, the seller will pay for the attorney's fees. It's not worth the headache to the buyer, in my opinion, to have that level of uncertainty, unless the timing of when you occupy that property doesn't matter to you. And there's very few buyers out there in this market that would want to hold on to wherever they're living for 6 months to a year, waiting for the tenant to be removed, perhaps through an eviction process, which can be stalled for a quite lengthy amount of time. If you're in that unique situation, or if you're renting an apartment month to month and you have that flexibility, maybe, but I would recommend strongly against it if you're a buyer. So that concludes my presentation on AB 1482 in the time of a pandemic, as I emphasized on earlier slides, and I'm now prepared to take any questions.
Wow. Thank you so much, Mr. David Bonaccorsi. And now you can unshare the file now. So before we get into our audience with all the questions, we actually have a lot of questions right now. So let's try to tackle them within the next 10 to 15 minutes. Before that, we'd like to give a very quick preview for our next T.A.N seminar. On June 1st, 3 weeks from now, Michael Lee, the Santa Clara University law professor, will be back to give us a second quarter update on taxation. As you know, 2021 has been a nearly unprecedented year for California state local property tax changes. The passage of Prop 19 has improved tax basis transfers for older Californians, but also set a tax trap increasing property taxes for children's inheritances. Michael predicts that 2022 will be a tax increasing year on the federal side, with proposed adjustments to the income tax, step up in basis rules, and reduction of estate tax exemptions. Be here in 3 weeks when Michael Lee of Re Attorneys will explain everything in detail. So now we'll begin our Q&A for our guest, Mr. Bonaccorsi. The first question from email. So Frank was asking, I have an existing rental leases contract signed prior to 2019. Am I required to add the addendums pertaining to the 3 disclosures covered by AB 1482? Property subject to rent cap, owner moving exemption, and property subject to rent control. File those disclosures in order to preserve those provisions? Or am I required only if a new lease is entered after July 2020?
Okay, thank you for the question.
And we
Before
have
I answer the question,
so maybe we can try to see
I'll break it down. It's an excellent question because it allows me to describe a part of AB 1482 that has changed over time. First of all, I like the fact that your next guest is a professor from Santa Clara University. You keep inviting him back. That's my alma mater, both for undergraduate and law school. So you couldn't pick a better professor than one from Santa Clara. So I'm very proud of that.
Good.
At any rate, what the question, the person asking the question is conflating or merging together two different concepts. There was a period, it was a grace period, and these grace periods are ridiculous because, again, most landlords that have one investment don't have an attorney on retainer that is a special, focuses on the changes of the law. So these dates sound good in Sacramento, but unless you're really active in CAR or in a real estate or a landlord network as a landlord, these dates come and go and you have no idea. So there was a grace period between January 1st and July 31st, where you could simply give a notice to the tenant of existing tenants under existing leases. In your case, the one that was beginning to lease in 2019 of this new law, and with the check marks in there and send the notice. So the answer to your first question is yes, you have to give notice to an existing tenant. And it's not only to the new tenant with a lease addendum, it's to an existing tenant. But what changed after July 31st, beginning on August 1st of 2020, is that instead of giving a notice, now it's required to amend the lease with these notices. And so in theory, and I don't think the legislature has really grappled with this, you are supposed to give an addendum and have your tenant sign off on it. Now, what happens if you got a kind of a tenant that's trying to protect their rights or play games with you and say, I know if I sign this, now I'm no longer getting all the protections AB 1482. If my signature means something, I want to still say that you're covered by AB 1482. So I, as the tenant, I'm not going to sign this. Well, the legislation really hasn't addressed it, and it just assumes that everybody is going to nicely negotiate. You're going to get a form that is pre-printed that I showed you earlier in this PowerPoint. You have the boxes checked off, the family move-in box checked off, and the tenant says, no, I don't agree to it. It's an addendum. It's a change of the contract. I don't agree, or I want to, the legislation doesn't deal with that. But in theory, you're supposed to have a signed addendum by the tenant for an existing tenant if you didn't give them notice before July 31st of the change. Of course, when you're negotiating a new lease, it's a lot easier to have that lease addendum as a standard part of your lease, and it's there and it's part of the overall package. In that situation, although not asked, what I would do is I would have, an email or even serve the addendum and have some memorialization that we gave it to you. You have refused to sign as the landlord. Protect yourself so that it's really not to be negotiated over. You're entitled to that exemption, and then you can argue to the judge if the addendum is not signed that you tried everything and that the tenant cannot exempt himself or require you to be subject to AB 1482 by the mere refusal of signing the document because he's gotten the notice. The tenant's gotten the notice. So those will be interesting cases that'll percolate at some point, I imagine. But no, so I didn't talk about it today, but you brought up a good question because when I talked about it in February of 2020, because at that time I was telling landlords, you have to give this notice out, but after August 1st, you have to have an addendum. Now that it's more than a year later, it's now in a situation where people are going to have to get addendums, whether for existing tenants or for new tenants, if you didn't give notice to an existing tenant that's under your lease currently before July 31st, 2020.
Yeah, that was the additional comments for that question. I can't believe the tenants would want to sign any rental contract addendums for an existing lease. So is there any incentive for them to do so? By the way, the properties are in San Francisco and already subject to San Francisco's rent controls. Am I too late to get this done? So that was additional follow-up questions.
Okay,
from
well,
friend.
again, this was my big caveat. If you've got a rent control jurisdiction in San Francisco, AB 1482 is likely not going to apply. Okay, because the San Francisco ordinance, rent control jurisdiction in San Francisco is classically one of the most tenant-friendly rent controls in the state, if not in the country. So AB 1482 is not a player. So the disclosures or the non-disclosures don't apply. You're subject to you're subject to San Francisco's local rent control, which are much more stringent upon you and much more tenant-friendly. But I would confirm that with an attorney that specializes in the San Francisco rent control ordinance, but that's my belief.
Great. Okay, and Linda asking, a friend of mine is renting a single family home in Fremont to a mutual friend, but they never had a formal lease. So the renters have lived there for over 5 years now. So the friend says he wants to increase the rent for the first time since the tenants moved in, and also have a lease sign. They want to have a lease sign and also raise the rent. Can the tenant refuse to pay higher rent and refuse to sign a lease now? Or can the landlord evict the tenant during the moratorium?
Hi, Linda. Linda's a friend of mine, so she's going to stump the speaker question here. Thank you very much. There's no anonymity, Linda. When you said Linda from Fremont, I know who it is.
You know who that is?
I do. As one of the friends I invited through social media today to make sure that people joined us that know me. No, it's a very good question, and it's a very tough question, but I think I can answer it. I'll break it down as follows. If the landlord is lucky enough to have the tenant sign the lease, that's the perfect opportunity for the tenant and the landlord as part of an increased rent that hopefully the tenant will agree to have that just cause addendum as part of the signed lease, exempting that landlord, presumably, if it's an individual, he's not a corporation, from AB 1482, and therefore no rent caps will apply. Tenant may refuse to sign it if there's increased rent and say, I'm not going to sign it. Then the second position at that point would be, okay, for now, let's just continue on and have a signed lease with the current rent and have just cause eviction addendum signed. So if that's the landlord, then at that point, you can simply give notices of rent increase thereafter because you're exempt from the rent caps, okay? If the tenant fails to pay rent, whether subject to AB 1482 or not, because we're in Alameda County, as long as the Alameda County moratorium is in effect, you can't go forward with an eviction based on non-payment of rent. How long is the Alameda County moratorium in effect that creates a 100% ban on all evictions? 60 days until after the county lifts its emergency order based on COVID. So I think I've answered your questions. Have I, Linda? Good, thank you.
Okay, great. And WW has a question. Will a single family home or residential townhome become subject to AB 1482 if we rent out more than 2 rooms with separate leases to different individuals? We're assuming homeowners do not live there. And also can rent out 5 rooms if owner also live there and share the kitchen only, but don't share the bathroom. What if renting out 4 bedrooms upstairs, plus there's a separate entrance on the first floor?
There's too many questions here, Coco. Let me just
I know. Too many scenarios.
Too many scenarios. I'm not going to answer all the different scenarios because that'll take 20 minutes. The general rule is this, and we'll return to it. If you live there, you cannot rent out to 2 or more people, more than 2 people, to be exempt from AB 1482, assuming you've done the disclosures. So whether it's a condo, a townhome, a duplex, whatever it is, if you're, again, duplex, you could rent out to the next duplex 10 people and give the disclosures, it doesn't matter. If you don't live there and exempt, you can rent out as many spaces as you want. As far as sharing the kitchen but not the bathroom, I have to look at the legislation. I think it's both. So if you share the bathroom but not the kitchen, then you may be subject to AB 1482. But I would have to drill down, and that really is worthy of research and time to get into that level of detail that you would need to do that offline with an attorney.
Yeah, so the question had a lot of detail. So let me finish reading the question, then you see whether you have any different answers or not.
Okay, sorry.
So,
I thought the question was over.
continue on the question. What if I rent out 4 bedrooms upstairs plus there's a separate entrance on the first floor with its own bathroom and kitchenette? So I'm not sharing with upstairs, except maybe using the washer and dryer upstairs, but they're still part of the single family home or townhome without separate address and utility meters, may be similar to like a JADU, but owners do not live there. So will this house become to be subject to AB 1482?
Okay.
So is that kind of going in line with what you were talking about?
Yeah, the big distinctions are twofold, okay? There's a whole separate set of rules if you don't live there, okay? If you don't live there, it doesn't matter how many places you rent, okay? As long as you're not a corporation or a REIT or an LLC with a corporate member, and you give the addendum or the disclosure before July 31st of 2020, you can rent 20 places. You know, it doesn't matter. You're not subject to AB 1482. Where it becomes relevant is if you do occupy the place, there are 2 rules that would potentially tripwire you into AB 1482. If you live there, you cannot rent out more than 2 places. If the 3rd place means all 3 units are now subject to AB 1482, or you can rent out to more than 2 places, 3, 4, or 5, as long as you have shared bathroom and kitchen. Now, your scenario says they don't live there. So she was going into, or he was going into, well, they don't live there, but share a kitchen, but not a bathroom. I don't care. They don't live there. As long as they're exempt, doesn't matter what the shared kitchen and bathroom arrangement is. That's only relevant if they live there. So I think my answer is still the same.
Okay, great. We're taking the last question from Tito. Tito saying, I'm renting a single family home in Sunnyvale. The room rental is based on the per room, right? So they have 5 people in 5 different rooms. Roommates issues are giving me a big headache right now, even though they have not done anything wrong legally. Okay, so I asked everybody to leave. They said they won't. What can I do? They are mostly staying here for the last 1 year since last summer.
Roommate issues is not a basis for just cause eviction if AB 1482 applies. AB 1482, if AB 1482 does not apply, you still have to wonder whether if they're paying rent, you know, at least through the end of the moratorium on June 30th, you can't evict them. Okay, so you'll have to wait, come back and ask me on July 1st and see where we're at.
Thank you very much, Mr. Bonaccorsi. This has absolutely been a very educational seminar. I hope everybody has a much better idea now of the renters protection laws in the post-COVID-19 future, basically. If you have any lingering questions for Mr. Bonaccorsi, I'm sure you can reach out to him, and he probably will be here, linger a little bit more for a little short while.
Coco, yes,
everybody.
I didn't mean to interrupt, but I'm surprised there's only 3 questions. I'm happy to take more questions if you want to keep the forum open. Absolutely.
Oh, sure. So I do have one more question here. So WW has a question saying, will a single family townhome become subject to AB 1482 if they change the room on the first floor, initially built as an office with separate entrance of a live and work unit into a JADU with private bathroom and a ready-made kitchenette purchased online, like from IKEA or something? Well, owner must live there in order to be subject to AB 1482?
Does the owner, I didn't understand the question. Does the owner live there or not?
Doesn't sound like owners living there.
Doesn't matter, as long as they're not, as long as they own it as an individual and they're not a REIT and they're not a corporation or they're not an LLC with a corporate member, they can be an LLC without a corporate member, then they give the disclosure through a just cause addendum to the lease, then they're not subject to AB 1482, assuming there's no local rent control ordinance in place. But I think this is what, Cupertino, you said, somewhere in the peninsula?
This one doesn't have a location, yeah.
Yeah, location, location, location. And real estate is everything as well as in landlord-tenant relations. So
Sounds
AB
good.
1482 applies if there's no local rent control or just cause eviction ordinance in place. Assuming there's none, AB 1482 won't apply if the person asked the question has given the just cause addendum disclosure.
Okay, great. So everybody, if you can unmute yourself, you can say a big thank you to Mr. Bonaccorsi before you leave. And then I'm sure we're going to see everybody on June 1st for the Prop 19 and the federal estate tax updates as well. Did our co-hosts unmute people? People are still muted. All right. Thank you so much, Mr. Bonaccorsi. And also, anybody who wants the slides, I have people asking for the slides. Please feel free to email me at coco10re@gmail.com. RE is short for real estate. So we'll get that slides over to you. We have the slides from Mr. Bonaccorsi.